Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of civil procedure, that too in relation to actual execution of decree for possession matters. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hi everyone, in this video I'll discuss about a latest Supreme Court judgment. In the important judgment titled SRIRAM Housing Finance and Investment India Limited versus OMESH MISHRA Memorial Charitable Trust, pronounced on 6th of July 2022, the Supreme Court has held that purchaser of the sued property from the decree holder is not entitled to file an application under Order 21 Rule 97 of CPC 1908 objecting execution of the decree by the decree holder. The facts of the case would be that a suit was filed for a decree for possession of sued property along with other prayers. The trial court decreed the suit in favor of plaintiffs while restraining the defendant from obstructing the plaintiff from enjoying the right of passage from the main entrance on ground floor to the terrace and from raising further construction. Execution proceedings were initiated by decree holders, and being aggrieved, the appellant company filed objections before executing court, which were duly considered and decided by the court. The said order was challenged by the respondent trust before the High Court by filing the petition, which was allowed, setting aside the order of the executing court. While setting aside the executing court order, the High Court held that if the objections were to be held maintainable, it would amount to a fresh trial, and hence the decree holder may not be able to get the fruits of the decree for the next couple of decades, while the illegal possession obtained by the appellant company with respect to the sued property shall remain with it. Being aggrieved, the present appeal has been filed with the allegation that since it is a bona fide purchaser of the sued property, the application under Order 21 Rule 97 of CPC is maintainable. The respondents, decree holders, submitted that only the decree holder or an auction purchaser is entitled to make an application, and the appellant company does not fall under both the categories. The Supreme Court has held that Order 21 Rule 97 deals with the resistance or obstruction to possession of immovable property by any person obtaining possession of the property against the decree holder. It empowers the decree holder to make an application complaining about such resistance or obstruction. On the other hand, Rule 99 of Order 21 deals with the right of any person other than the judgment debtor who is dispossessed by the holder or holder of the decree for possession of such property, or in case where such property is sold in furtherance of execution of a decree. The said provision vests any person with the right to make an application complaining about such dispossession of immovable property in the manner prescribed above. Rule 98 and Rule 100 deals with the power of the court to pass appropriate orders upon an application preferred under Rule 97 and 99 respectively. Insofar as Rule 101 is concerned, it confers jurisdiction on the court as well as casts an objection to determine the questions relating to the right, title or interest in the property, if any, arising between parties on an application made by the concerned person under Rule 97 and 99 in the same proceeding or adjudication and not in a separate suit. Lastly, Rule 102 clarifies that Rule 98 and Rule 100 shall not apply in case where resistance or obstruction in execution of a decree for the possession of immovable property is offered by transferee pendentiae. That is, the person to whom the property is transferred by the judgment debtor after institution of the suit in which the decree sought to be executed was passed. On conjoint reading of the aforesaid provision, it can be observed that under Rule 97, it is only the decree holder who is entitled to make an application in case where he is offered resistance or obstruction by any person. In the present case, as admitted by the appellant itself, it is a bona fide purchaser of the property and not the decree holder. As available from the material placed on record, it is the respondent trust along with the legal heirs of the late N.D. Mishra who are the decree holders and not the appellant. And therefore, it is obvious that appellant cannot take shelter under Rule 97 as stated above to raise objections against execution of decree passed in favor of the respondent. Further, Rule 99 pertains to making a complaint to the court against dispossession of the immovable property by the person in possession of the property by the holder of a decree or purchaser thereof. It is factually not in dispute that appellant purchased the said property from Mr. Yogesh Mishra via sale deed and was in vacant and physical possession of the property since then. Had it been the case that the appellant was dispossessed by the respondent trust in execution of decree, the appellant would have been well within the ambit of Rule 99 to make an application seeking appropriate relief to be put back in possession. On the contrary, the appellant in the instant case was never dispossessed from the property in question and till date, as contended and unrefuted, the possession of same rests with the appellant. Considering the aforesaid, the appellant cannot be said to be entitled to make an application under Rule 99 raising objections in execution proceedings since he was never been dispossessed as required under Rule 99. Application under Rule 97 and Rule 99 are subject to Rule 101, which provides for determination of questions leading to disputes as to right, title, or interest in the property arising between the parties to the proceedings or their representatives on an application made under Rule 97 and 99. Effectively, the said rule does away with the requirement of filing fresh suit for adjudication of disputes. Now, in the present case, Order 21 Rule 101 has no applicability as the applicant is neither entitled to make an application under Rule 97 nor Rule 99 for the reasons stated above. Accordingly, this court finds no substance in the argument raised by the appellant. In such circumstances, executing court had no occasion to frame issues and give directions to parties to leave evidence on objections raised by the appellant. By doing so, the executing court transgressed the scope of Order 21, Rule 97 and Rule 99. Therefore, the High Court rightly set aside the order of trial court entertaining the objections filed by the appellant under Order 21, Rule 97 to Rule 102. So that's it for today. Hope you find this video helpful. Thank you.